So good evening, everyone. My name is Daniela Caruso. I am a professor of law at Boston University and also the director of BU's Center for the Study of Europe, housed in the Pardee School of Global Studies. It is an honor for me, really, to introduce two phenomenal guests this afternoon. This is the first in our series of events around the theme Structures of Inequality, and I really can't think of a better start for this series. Dr. Eddie Bruce Jones joins us today from our own School of Law here at BU, where he holds now the prestigious title of Clare Visiting Professor. His primary base is in London, in particular at Birkbeck College, University of London, where he is Deputy Dean of the School of Law and Reader in Law and Anthropology. Dr. Bruce Jones's research focuses on migration, racism, sexuality, colonialism, state violence, and citizenship. He is the author of a 2016 book, Race in the Shadow of Law, State Violence in Contemporary Europe. He is as well the co-author of a forthcoming casebook titled Race and Law in Europe, which happens also to be the title of this webinar. This new casebook provides empirical knowledge as well as a theoretical framework for understanding race in the European legal system. This is an urgent intervention because, as we shall see today, race remains even now a severely underexplored legal concept in many European countries. Beyond academia, Dr. Bruce Jones is an active member of the boards of several institutions, to name just a few: the UK-based Institute of Race Relations, the UK Lesbian and Gay Immigration Group, and the Center for Intersectional Justice in Berlin. Respondent to Dr. Bruce Jones's presentation today, we have another very special guest, and may I add, a wonderful friend. Gráinne de Búrca is Florence Ellinwood Allen Professor of Law at NYU School of Law. She is also faculty director of the Hauser Global Law School and director of the Jean Monnet Center for International and Regional Economic Law and Justice. Before joining NYU, Professor de Búrca held tenured posts as professor at Harvard Law School, Fordham Law School, the European University Institute, and Oxford University. Professor de Búrca is an authority in matters of European Union law, international governance, and human rights law. Their many accomplishments and scholarly publications include a forthcoming book titled Reframing Human Rights in a Turbulent Era. I can't wait to read and share with the center this book, actually. Since the enactment of the European Equality Directives almost 20 years ago, Professor de Búrca has been researching the possibilities opened up by those laws and, most of all, the reasons why anti-discrimination laws in Europe have remained critically underutilized. A heartfelt thank you, Eddie and Gráinne, for being with us tonight. Eddie, please take it away.
Thanks so much, Daniela, and thank you, Elizabeth, and thanks to the Center for the Study of Europe here at Boston University for having me. I'm delighted to open the year, the academic year for you, and thanks so much, Gráinne, for offering to give comments on the talk. I teach your work and teach European Union law, so you're named that kind of a household name, if you will, in our school. So thank you for your comments. So in the talk, I'm just going to be discussing some of the legal and social concepts associated with race in Europe. And I'll give a few examples of different particular concepts within Europe, but I'll touch upon Europe more generally just to give an idea for those who aren't familiar with the frameworks of regulation in Europe, and particularly the European Union and the European Court of Human Rights System, which is the Council of Europe. So those are two different entities, and many people don't know that, including much of the British public, it turns out, during the whole lead up to the Brexit debate. They were getting conflated quite a lot, which was interesting for debates. And then I'll shift from talking about race and how it's used legally and socially to talking about a particular case that I've been working on in Germany for a number of years, for 15 years. And the case isn't one that's covered by equality laws in the European setting, but that's kind of the point, because some of the things that are missing from the regulation of, well, the legal provisions that exist for the protections against race and racism in the European setting make certain types of discrimination and racial animus and institutional forms of racism invisible. And this case is a case in point. It's also a case that will have resonances for the US listeners because it's a case about death in police custody. And it's one that involves someone who had been taken into custody and then died under mysterious circumstances. So it exposes kind of the invisibility of being able to talk about and see race on one hand, but on the other hand, it exposes the difficulties in trying to get a legal remedy when you don't have all the evidence, but that the evidence kind of lies in those institutions that are accused of having done wrong. So how do you check racism within an institution that holds the investigations for themselves? Seems like a basic question, but it's one that has particular expressions in the European context and in the German context, which I'll be talking about, which may provide a point of comparison. I'm going to start a slideshow, and hopefully that will help, because I'll also be going in and out of quoting from other material. Race, law, and structural racism in Europe. At the European level, and I know there are non-law students and non-law scholars in this webinar. So the European Union is made up of 27 member states, and the court jurisdiction there is the Court of Justice of the European Union. And within the EU, there are certain guarantees about racial discrimination and equal treatment that are included in the primary treaties of the European Union that govern everything within the EU member states, and the directives. And so the directives are the secondary legislation of the European Union, and one of the directives, which member states have an obligation to implement through their national laws, is the Race Directive. So it has a very broad scope. It applies to public bodies, it applies to service providers, it applies in lots of areas of public life. It doesn't apply directly to the police in the ways that we might want it to. It applies to, equality has to be ensured in certain ways through any governmental body, public body. But it doesn't provide very specific regulation of how the police behave, how they engage with people that they apprehend. Nor does it provide a lot of detail on how to deal with police violence, disproportionate use of force, and all of that. So it's a way to, it's usually used as an equalities provision. And there's a discussion, a very recent discussion, and thanks Daniela also for reminding me of the recent discussion at the European Union level to, over the next 5 years, to change some of that and to make amendments to the types of provisions that exist to incorporate some of the things that don't currently get covered. So I'll talk about that briefly in a moment. And then there are other guidelines and ordinances around equality and the protection of certain types of rights related to race and ethnicity, which have a complicated relationship linguistically. So we'll talk about that in a bit as well. Then there's the European Convention on Human Rights, and the European Convention system names race, for example, in Article 14 of the European Convention on Human Rights. But the way that works is that if another human right other than the right to equal treatment has been basically either violated or if there's a question of whether or not it's violated, then you can append an equality claim within the convention provisions, which is Article 14, to your claim of that other article. So for example, if you are unjustly killed or that your death isn't properly investigated, but it was under mysterious circumstances, then your Article 2 claim, which is that article that prevents you from being unjustly killed, is invoked or it's violated. And you can say, if it's the case, if that were due to racial animus or some discriminatory aspect of the treatment you endured, then that could mean that you have an Article 2 claim with Article 14 attached to that claim. So it only works within the context of the European Convention on Human Rights. And one could argue that it has a normative effect because it's raised to the level of being important in the context of human rights. But again, that also doesn't necessarily add a lot of specificity to the way in which policing and deaths in custody would be treated. Article 2 has a lot in it, and that's one of my interests, and I'll touch upon that briefly, but there are very technical reasons why I think Article 2 is interesting for looking at like those less visible forms of institutional racism. I'll talk about that in the example of the case that I use. So some of the improvements on provisions to protect against racial discrimination that are being discussed are to apply equality aspects to policing practices. So training, how police gather data about their own practices in relation to racial minorities, education, hate speech. Hate speech is, you know, it has a really strong presence in these new proposed kind of, this proposed action plan is what it's called. Better data collection, and I'll talk about data in just one moment, but the point there is that there should be data that allows us to see patterns of racial discrimination, and that data isn't necessarily collected in all member states in the same way or at all. So that's kind of what I wanted to focus on with these proposed, this proposed action plan that's just been released, I think, last week. But there is a discussion about how much or how little the European Union, because this is from the European Union, not from the Council of Europe, how much the European Union actually engages with member states in trying to achieve a certain type of protection against racial discrimination. And the criticism has been that there is some protection for some types of discrimination, but A, that protection isn't implemented in the same way in every member state. And B, there are areas of, you know, whole areas like policing or housing in terms of patterns of housing discrimination that really aren't addressed in EU law. So this is a step, I think, towards making provisions apply where they don't currently apply. But I think that some of the problems that I'll outline with how states interpret their current obligations under EU law will persist, I think, because, you know, unless there's a very specific way of trying to get states to do certain things, the action plan, which is about 20 pages long, the kind of description of it by the European Union, doesn't really address some of the interpretive differences between how states see race and their obligations to protect against racial discrimination. So to give you just a really basic sense, and I'm also not an expert in all of these countries, but to give you a basic sense of how some countries filter the obligations to protect against racial discrimination into their national laws, the United Kingdom has an Equality Act that covers racial discrimination. It's now a combined act that had before been, you know, several different acts that are now put into one. And it covers racial discrimination, direct and indirect discrimination, as it must as per the European Union legislation. It also has, you know, a depth of case law that allows a very nuanced way of viewing what race is. I mean, I say that in relative terms, though, because there isn't a lot of necessarily a lot of social debate around what race could mean under the act, but there is some. I mean, there's been writing about whether caste belongs under the act, which has been quite controversial, or writings about intersectional discrimination that should be covered under the act. So intersectionality isn't a concept that's recognized really in European member states. And the United Kingdom had a draft provision in the Equalities Act in 2010 that never went into force that would have covered intersectional forms of discrimination. And that's just discrimination that's based on more than one characteristic at the same time. So if someone's discriminated against because they are a Muslim woman, that could look different than discrimination based on being a Muslim man, which might be the assumption, or just being a woman, because of the very particular position that a Muslim woman might be placed into via stereotypes, etc. So that kind of discrimination isn't recognized, but there were debates about it in the United Kingdom. And the Equality and Human Rights Commission is an agency that oversees how these cases look on a broader level in the United Kingdom. In Germany, there's the German Basic Law, which is the Constitution of Germany, and that has a provision that covers racial discrimination. Is the asterisk there is that there's a debate socially as to whether that provision should be changed to take race out of the Constitution and to replace it with racial discrimination. And that move has been controversial, partly because some argue, some legal scholars argue that taking race out as a noun and as a way to hook into other debates about this concept of race and how it's constructed in other member states of the European Union, or within the context of the Council of Europe in thinking about human rights, could do something to water down the ability to have a transnational discussion about race and racism for Germany, so that it could be difficult then to have a discussion outside of Germany about the concept of race if it's turned into an adjective and simply kind of left to people to define what it is that we're talking about. So it makes the language more convoluted. And I think that's a good argument from a legal perspective, because I don't think that there is a very nuanced debate in the first place around what the concept should mean. So to take it out, I think, is a bold move that could have some serious effects. Then there's the German Law of Equal Treatment, which is their Equalities Act, more or less, that came into effect in 2006. But there, it hasn't been used very much, because ultimately the idea of racial discrimination in Germany has been one that has been socially connected to this concept of biological race. And that actually stood in the way, that along with the freedom to contract, stood in the way of this act getting passed in the first place. So when the act first came into effect, it did so partly because a German parliamentarian had to give a talk on the floor of the German parliament and say, I was a victim of racial discrimination because I tried to get a flat, an apartment in Germany, and the landlord basically said she wouldn't rent to me because she thought the flat would smell like curry. And that was because he was of Indian descent. And that was legal before the act went into place, because there wasn't this way of understanding what these types of statements meant in terms of racial discrimination. There was more of a broad tolerance for this type of intolerance based on a very strong sense of the freedom to contract in Germany and the freedom to rent your flat to whoever you wanted, which is, as you could imagine, an outgrowth of having lived in a very repressive system where the state was interventionist to a large extent. But then discrimination law and how the state regulates discrimination needs to then come into view. So that passed, but many argue that it's difficult to take advantage of it because cases about racial discrimination are very difficult to argue persuasively in court. And many people, because there's a cap on how much you can recover, don't think it's worth it to bring cases of racial discrimination. I think the cap is 5,000 euros. In France, race was covered under the French constitutional protections until 2000, oh, sorry, it's a typo, it should be 2018. So recently, the French Parliament voted to remove race from coverage under the Constitution. It's not that they, so that sounds, I don't know, I was gonna say it sounds worse than it is, but maybe it is that bad. The reasoning is that France sees race as a biological inaccuracy, so that it's biologically not a thing. So, you know, we all know this argument that race is a biological fiction, but the part about it then being a social construct has not made its way into the way that France deals with racism. So the idea is to remove race because it shouldn't show up in official documents because it's not a biological truth. Additionally, France for decades has criminalized the concept of race in terms of collecting data and keeping data on racial origin. for similar reasons. And so that means that the state can't officially sanction the collection of racial data. It definitely doesn't collect racial data itself, and only for certain very particular reasons can non-state organizations collect racial data, which means that it's very difficult to prove patterns of racism in France. And this is also the way that France argues it complies with the European directives on racial discrimination, because by outlawing the term, the French position is that they have dealt with racism by criminalizing it, which is a very harsh sanction. But that means in order to win a claim against an employer for racial discrimination, one has to appeal to the Ministry of Labor, which then investigates the employer, which then potentially brings a criminal sanction against the employer. And that usually doesn't happen because that's a very, very harsh type of sanction. And it's very unlikely that the Ministry of Labor will bring such a harsh sanction against an employer unless there is clear and extreme evidence of racial animus. And so there haven't been very many cases, well, there hadn't been up until 2005, and I'm not sure in the last 10 years whether that's changed a lot, but there hadn't been very many cases brought through that route in France. And then the Netherlands and Spain both cover race and have race as a term within their constitutional within their constitutions, and both have equal treatment acts that cover equal treatment based on race. Linguistically, I won't go through all of this, and I think I've covered some of this in what I've said. In the United Kingdom, race is used quite liberally as a term. I think, of course, there are ways in which it's problematized, and there are ways in which I think certain uses of race have fallen out of favor. But statistics are kept based on, disaggregated by race, by police in their policing activities, but also in monitoring forms, so voluntary monitoring in employment contexts and in other contexts. For example, I studied a language at night, and when you go to, and it's sort of funded, it receives some funding, and there's a monitoring form for to keep track of what types of people in terms of socioeconomic background, age, residency status, and racial and ethnic origin. And that's, kept voluntarily, but there's a more liberal approach to collecting data in the United Kingdom to track both discrimination, but also targeted types of funding. In Germany, the word in German is Rasse, and that's loaded. So the term is loaded partly because it's when Germans tend to think of what that word means and where it's used, World War II and the Nazi regime come to mind, and that invokes this idea of biological racism, which is also, part of the reason why there's a reluctance to use race rather than other terms that don't do quite as much work or don't do the same type of work as race does. So instead of saying race, people in Germany will say ethnicity, which is not the same thing, or they'll say origins, or they'll say background, but a lot of times that implies that they're talking about a migration history. So there's even this term migration, people with migration history. Or they'll use proxies for race that they understand as proxies. So the language that you speak at home is understood as a proxy for race in the educational context. But that's not necessarily the case if the language that you speak at home is German and you are a Black person, or if the language that you speak at home is, I don't know, is a different language, but you are racialized as white, you speak fluent German, and you're not treated as someone who's different based on race necessarily. So it's not a very, it's not a reliable proxy, but it's being used in the German context and also in the French context to some extent. And in the academic discourse, sometimes race is not used, but race is used in English, and it's put in italics. And so it's put in a category of, an analytical category that exists more outside of Germany. And in that way, in academic discourse, sometimes, you know, that helps to support this concept that race is an imported concept from America, and that Americans are obsessed with race, and that it doesn't quite work in Germany, but we were using it in order to be able to analyze it for use elsewhere. So that also gets filtered into academic discourse, you know, not only in the humanities, but also in areas like law. In France, as I mentioned, the classification of people by race has been criminally prohibited, and the term has been taken out of the French Constitution, and that has an impact on how statistics aren't collected. In the Netherlands, there's a discourse around race and whiteness that's growing in an academic sense, but there's still a narrow understanding of what constitutes racial bias or racial actions, and this goes for, I think, a lot of countries in Europe, and it's not unique to Europe. So being able to understand and theorize institutional forms of racism is a very difficult endeavor in the Netherlands, and I mean that's really unsurprising, because there's not a vocabulary that's really attuned to institutional forms of racism. And in Spain, like in Germany, there's a conflation of migration status, nationality, and race, so that there's an assumption that if you are racialized as non-white, then that you're not Spanish in a certain way, and that, of course, leads to different understandings of what could constitute racism, because if it's taken for granted that someone who is Black, for example, is not from Spain, then asking them questions and kind of targeting them for passport controls becomes not an issue of racism, but just an issue of obvious common sense, as it's discussed in policy terms. So there was a case a long time ago now about a Black woman who was constantly asked for her ID on a train platform in Spain, which ended up being, you know, brought to the UN Committee on Human Rights. But all of these things, you know, overlap in European context. So the assumption that to be, you know, a non-white person is to be from outside of the country is sort of commonplace in all of these places. So there's also, besides the statistical analysis or the statistical aspect of racial discrimination and the legal provisions that apply directly to people who are experiencing discrimination, there's a broader discussion, and I think the Black Lives Matter movement is just one iteration of a broader and longer discussion about the relationship between modern forms of racism or contemporary forms of racism and colonialism and practices of you know, globalization, and how that impacts domesticity, so the domestic sphere in European countries. So this is just a quote from one of the founders of the UK Institute of Race Relations, Sivanandan, who says, "We are here because you were there." And that's kind of a call to understand the relationship between global flows of people, colonialism, and migration, and how, you know, today when we see the demographics of the UK and we see what's happening with things like the Windrush scandal, and I don't have time to go into all of it, but the idea that people should return home is a bit preposterous from this kind of long view of history, considering that that many Caribbeans and South Asians went to the United Kingdom as part of a really important labor force, but that there wasn't a lot of care taken to make sure that these people who were ultimately subjects of the British Empire during the colonial period were accounted for. So many people who came in the generation of Caribbeans who arrived in the 60s to the United Kingdom were able to come because there weren't travel restrictions. Then those travel restrictions were put into place over time, and relatively recently, the Home Office tried to send lots of people back to Jamaica and other Caribbean countries on the basis that they never really, that their paperwork wasn't in order and they didn't have a right to stay. And then it came out that some of the paperwork was destroyed, or that wasn't issued because it didn't need to be issued at the time. So there are a lot of ways in which we can connect the type of issues around immigration control and racism and colonialism together. And my colleague Nadine Elanani, who's my colleague at Birkbeck, wrote a book called Bordering Britain, which brings together all of these aspects, including the Brexit decision, into the view of looking at colonialism as a way to organize those topics. I'll skip over some of this. And just to give you a sense of the German context on this point, the discussions around contemporary German identity and the shift of German politics to the right in recent years has also taken on the language of racism and biology. I mean, really, it shows that biological racism is not actually so far removed from some of the ways that racism expresses itself in social life. So there were posters made by the Alternative for Germany, which is one of the most powerful far-right political parties in Germany. It became the third largest political party in 2017. And they made posters for the election campaign. I think these are from 2016. And it says, "New Germans, we'll make them ourselves." So, and these posters were spread throughout Berlin. There are tons of them, but these two, I think, were especially telling. And then the next one says, "Diversity, we have it already." And it's 3 different types of German traditional outfits. And this sense of seeing German identity and almost German survival as a point of social debate for the purpose of political interventions is really quite stark. It's not new. It's not something that's unique to Germany either, but it shows that the debates about racism and the provisions against racial discrimination are linked to mainstream debates about German identity and politics. And it also shows that there is a sense to which people feel authorized to inhabit this kind of almost biological racism. And it contests the idea that biological racism is out of the picture so that the term race should then be ignored. I think it's a really strong indictment of the idea that we've gotten over using the term and we should shift to other concepts. So I'm going to move on to discuss this case very briefly because I know I'm kind of running to the end of my presentation. So there is a case that I've been working on from 2005. I'm going to read a couple of little excerpts because I think it's more efficient that way, and then I'll hand it over to Gráinne. And this 2005 case is of a man named Uri Jalloh. He's from Sierra Leone, and he was seeking asylum, and he had temporary leave to remain in Germany. He burned to death in a police cell in a small city in Dessau, and the circumstances of his death remain unclear more than 15 years later, but not for lack of trying. His friends and family in Dessau and beyond organized a legal team to represent their interests alongside the main prosecution and commissioned an independent autopsy. And they would also go on to provide the motor behind years of litigation through multiple appeals alongside a strong campaign to keep the spotlight on Jalloh's death. The responses to his death by activists served as a social and educational forum, which continues to be instructive in the German context, one that points to deficiencies in the legal process in recognizing institutional forms of racism and the correctives that can be attempted by non-legal means. Jalloh's case is one of the several high-profile policing-related deaths of people of color in Germany that served a significant anchoring point for political activism and social debate at the junction of racism, migration, and policing. And it's been called the most important death in custody. Part of the issue is that the circumstances under which Jalloh died are not only out of view because he can't testify himself, but a lot of the evidence was either missing or destroyed inadvertently or otherwise. So the firefighters who arrived at the scene when the police called them were surprised when they found someone in the cell because they weren't informed there's someone in the cell. Police testified that they turned off the smoke alarms that registered the fire, claiming to have assumed that the alarms were faulty. So they turned the smoke alarms off while the fire was going on. They also claimed to have lowered the volume on a radio where when they turned it back up, he was screaming for help. And the first trial was thrown out because there was conflicting evidence. The CCTV cameras were turned the wrong way. The forensics footage only captured the first few moments of the collection of evidence, so the chain of custody of the evidence had been broken. And the prosecutor started from the presumption that he set the fire himself. So there was no question as to whether someone else set the fire or whether he set the fire. And that meant that no questions to that effect were allowed in court. And so the prosecutor has a lot of power in this case. And there's very little the family of Jallow could have done in order to change the charges, other than appeal to the judge, which did not work. So part of the 2005 campaigns around Jallow's death was to raise the profile of a lack of recourse if people die in police custody. And so in 2011, literally while we were in the courtroom watching the Jallow trial, there was news of a woman who'd been shot in the stomach by police in a job center in Frankfurt, who had been arguing with one of the job center employees, and the police said that she had a small pocket knife and it was in her purse and she took it out. And so rather than to try to use some other means to disarm her, they shot her fatally and she was killed. And also there, the prosecutor refused to bring an investigation around a disproportionate use of force. And these cases have now produced a kind of joined up type of campaign that looks at the quality of the cases rather than waiting for statistics to be produced, because there are no disaggregated statistics about who's facing disproportionate force. And the last thing I'll mention is just that in the process, activists and family members have learned a few things. One, that the investigation, if it's going to happen, will need to happen independent of the courtroom sometimes. So they commissioned in the Republic of Ireland, we visited a man who was born in Belarus but lived for a long time in Ireland, and he offered to rebuild the cell that Jallow died in and do a fire test for us. And that fire test served to incite a special investigation. It wasn't used in court because it didn't have the requisite specifications, and it wasn't sanctioned by the court in advance. But that type of activity was thinking outside the box in terms of how to get people to listen. But it isn't a structural change because there's still the need for families to have to do the work and put in the money and raise the funds, and to go outside of the country to get someone who isn't so close to the issue, because no fire experts will touch this case in Germany. And it also raises the question of what can be done at the European Court of Human Rights level. And so that may be the next step. And I won't go into details about that because they're more technical, and I think they're more for a legal audience that has some background in human rights in Europe. But that's all to say that this case is ongoing still 15 years later, and it shows some of the nuances of how racial provisions or the lack of certain racial provisions and the social discussion of race filter into things like policing, which I know is really a relevant topic also for the US listeners. So with that, I'll hand it over to Gráinne. Sorry for going over time.
It was great. Thank you, Eddie. Gráinne, your first response, and then we'll open it up to the public. Thank you so much.
Great. Thanks so much, Eddie, for a really interesting, always depressing, but at the same time extremely interesting account, or at least overview of some of the dimensions of the intersection of race and law in Europe. And as you say, it's a huge topic and there's so many layers to it. And I think you did a great job in sketching out some of those both the two layers of supranational European law, these two different systems, and then taking 5 states and showing us the very different legal regulation and social understanding and social vernacular almost around race in those countries. And then sort of bringing it all, concretizing it all with this one case that you present to us, the Uri Jalloh case, which kind of brings together a whole set of the different issues you've been trying to illustrate through the abstract presentation of all of these different intersecting legal regimes. You know, how is it possible that despite the fact that there's national law on race discrimination, EU law on race discrimination, ECHR law on race discrimination, that we could be 15 years on and there isn't justice yet in this particular case. And it's just one case, as you say. Incidentally, for the American audience listening, you know, shocking though this case is in the German context, there's a headline in the Washington Post today, which, you know, I've lived in the US for a long time and I still never cease to be really shocked at the statistics. Over 1,000 people have been shot and killed. I think it was 1,100 and something, shot and killed by the police this year. 1,100 people shot and killed by the police in the country. The statistics are staggering. I don't know what the racial breakdown of those numbers are. I could make a guess at it, but it is staggering. So the European picture is not rosy, but maybe the levels of lethal violence by the forces of the state that are set up to protect might be somewhat less. Nevertheless, all of the same kinds of issues that have really risen to the surface recently in the US, particularly with the latest outrage, the George Floyd killing, have managed to shine a light again on the kinds of cases that Eddie has been investigating for a long time and bring fresh impetus and above all maybe a sense of political, as we put it, energy or willingness or at least responsibility. So the fact that, as Eddie said, there's a new European action plan against racism, I mean another action plan, but nonetheless, and there are some new provisions in it and some new promises, some new commitments. Well, it's a long time since we saw new promises or commitments around discrimination and particularly around race discrimination in Europe. So that is something, you know, to sort of see as a, you know, one consequence of this really impressive global spreading of the renewed focus on racial violence and policing in particular that came from the George Floyd killing this year. At the same time, you know, just bringing the focus back to Europe again for a moment, one temptation I can imagine is to think, what good is the EU? What good is the ECHR? You know, this is a problem of racism in Germany, the kind of racism that we have in all European states. It's sort of systemic. It doesn't manifest itself in the way that the laws sometimes seem to require this very overt, you know, overtly intentional, individualized act of racism. Rather, it's, you know, it happened in this context and so on, and the difficulty in bringing the legal provisions to bear on the event that's happened, you know, seeing the systemic racism clearly and so on, that issue seems to present itself. So one thing that occurred to me when you started talking about the German case was, you know, is this one in which, you know, we could, you know, EU law or ECHR law or any other laws of any good really, because the very basics are missing, you know, a willingness, the factual circumstances, the police's, you know, willingness to acknowledge what happened. Secondly, willingness to have an investigation, provision of information, you know, even local routes to justice for these people. You know, are we looking in the wrong place if we look to Europe for a response? But I thought your follow-up was very interesting because you sort of gave the answer to that in a way by saying sometimes you have to go outside the system. So it's precisely the closing of ranks around and the refusal to acknowledge or shine a light on domestic, institutional, and social racism that makes the supranational level actually useful and interesting. And in this case, the transnational level too, the going to Ireland to find a Belarusian specialist who was able to reconstruct this for you. So I thought that was really interesting, that both that insight that I think I, you know, as a sort of someone interested in human rights, come back to so often, that, you know, you hear this discussion of why, you know, why the international system or the European system, let's start with, but actually external accountability often is the only way to start the accountability process, because, you know, systems close around and protect, especially when it's the institutions of the state violence, they tend to protect themselves from scrutiny and so on, and that actually it does take sometimes an external lens, an external procedure, an external process to crack open that system again. So even though people are resistant to, you know, the supranational, the meddling of the European courts, or what competence does the EU have for this, or why take it to Strasbourg and so on, that often, as you say, becomes the only route, because the domestic routes are just closed off factually through non-provision of the relevant evidence, you know, and concealment and so on. So I think those are two really interesting observations. Then, of course, we come to the question, well, what can the EU or the ECHR offer then, you know, in this circumstances where the domestic system, even, I presume that there are laws in Germany that should address police violence, deaths in custody and so on, but obviously it's not working here because there's been a closing of ranks around what happened, and a blocking of access to justice for the family. You know, there we come back again to this issue of, well, what kind of anti-racism law does the EU have? And as you say, it's very piecemeal and partial. We had this directive, which seemed an impressive for its time piece of law. It's been unevenly implemented, as you said, in different states. So, you know, the law itself has been controversial, especially in Germany. They don't like it because, as you say, they think it interferes with private autonomy. They think it interferes with subsidiarity. What's the EU doing getting involved with race discrimination law? So first of all, it's challenged in itself. Secondly, it has problems in implementation because different states, as you showed us so nicely, understand it and implement it in such different ways. Thirdly, what kind of ongoing monitoring does the EU do of the extent to which, and the Fundamental Rights Agency tries, the Commission, so on, but they have limited resources and it's minimal supervision and so on. So the distance between the supranational level and where the rubber hits the road is also an issue. And then fourthly, and finally, as your case shows, even if that law is in place, even if there are legal provisions, what do you do when that law isn't respected, when there are evidentiary ways and institutional ways to block access to a remedy? And I think it shows both the intractability, you know, the difficulty of, first of all, getting consensus on the adoption of law, secondly, getting that law properly implemented and observed, thirdly, getting the law monitored, and fourthly, actually putting it into practice. But I think your talk also showed that, you know, these different levels are all important. They're all relevant, you know, and so, you know, if you didn't have these alternative routes, so the Strasbourg Article 2 investigation of killing, that's been a really important route, however flawed the Strasbourg case law might be. I think the very first case, right, that brought Article 14 together with race was an Article 2 case, a Roma death in custody. So, you know, race kind of brought Article 2 and Article 14 together. And there is now a series of cases on the importance of investigating deaths in custody, and especially when there's a racial animus. So I think, you know, I hope that proves to be something that can be an additional, because I think the other lesson is that all of these different tools are helpful. Being able to go to the Commission to see that EU law is being implemented is helpful. Being able to go to the ECHR to say, we didn't get a domestic remedy and there hasn't been a proper investigation of this death. The evidence wasn't looked at and so on is helpful. And you know, as you say, there isn't enough detail, you could say, in the EU Race Directive to look into the specifics of what policing has to do, but it covers police, right? And it should be, it's a public authority, right? And so whether there's a way in which a creative lawyer might be able to bring a case through a domestic court and get it to Luxembourg, that would be another maybe way of cracking open the domestic nut. I'm talking a lot, so I'll just want to finish maybe with one other kind of observation. So Daniela mentioned that I'd done some research on the implementation of the directives, and unfortunately I started a project some years ago, like so many other projects that got suspended as I went on to other things, but I'd actually started to get some really great research assistance I had digging into different jurisdictions in the EU to try to, I really wanted to understand why after what was then, I think was 12 years, have so few cases on race come to the Court of Justice. It just didn't make any sense to me. There were all these age discrimination cases, you know, a couple of religious discrimination cases, good few sexual orientation, but, you know, one or two, really, maybe three on race. And it made no sense to me. It's not like Europe doesn't have, you know, big problems of race discrimination, what's happening. And so I got quite some really interesting data on a number of EU member states, one of which was Germany. I should send you actually the research because it might be of use to you since I didn't use it. But it was really remarkable how there were cases brought and they would never mention EU law. It was never, you know, so there was no chance of a reference being made because EU law wasn't brought into it, even though these were clear, straightforward, falling within the remit of the directive kind of cases. They weren't, or, you know, there'd be they treat it as a language issue or something, but they would find this wasn't a case, you know, involving race. There was an example of someone who, and he, I suppose you could call it a kind of a test case, maybe you know it, but he was being turned away from nightclubs, a black German man, and he, you know, went to visit 6 nightclubs with white friends, and in every case he would be refused and they would be admitted and so on, and brought these cases. But again, even though that would be access to services and would be covered by the directive and so on, the court never, you know, referred it. So it wasn't that people weren't trying to litigate these issues, but that they weren't filtering up, they weren't being sent to the EU. So I just thought that was interesting that, you know, that when you're looking for these routes to the external framework of accountability, sometimes the domestic system can close those off as well.
Yeah, that's really, really helpful. That's super interesting. Yeah, I'd love to see that research if you've
sure. I'd be happy to. I'd be happy to start. I think I should stop there. I could talk on endlessly, but I know we have an audience and I'm sure Daniela has questions too.
The reason why you are the guests today is precisely because you can talk endlessly about this and never make us feel that you're talking too much. Not for a moment, quite the contrary. So I wanted to tell the webinars, the webinar attendees that I see here just in the form of a number, that the Q&A is open at this point and that we would like to entertain their questions. But meanwhile, let me ask a question now that I have. 2 Europeans in America very steeped into the debate on race in this country with the comparative experience of another country. So first of all, when you say, when Gráinne says the best forms of intervention oftentimes come from outside, in Europe we have a pretty articulate system of outside revision. The question is how to trigger it, how to create a discourse that facilitates that triggering. In the United States, it's not clear whether we have, it's unfortunately kind of clear that we don't have the same possibility for external kicks with real binding efficacy on the ground. So the question is, do we have other remedies? In other words, if you had to compare the 2 landscapes, and if you could equalize for all the variables, you know, the numbers, the differences, etc., would you see the strategy as a lawyer being completely different in the United States than it is in Europe, vis-a-vis tackling the problem of racism? And of course, you know, it always then boils down to specific examples. In the case of Eddie, the main interest in your talk completely seemed to be the question of policing. How do we should we tackle one problem at a time? Like, as a lawyer, you tend to focus on cases of high visibility, and so attacking the policing aspect might be actually a lawyerly strategy. But it could be also that looking at the system requires a more horizontal strategy that looks into the other aspects that lead to the rationalization of society. We could go for specific cases, we could go for general systemic things like education, housing, zoning, the urbanization or disurbanization of centers all over Europe and in the United States. We could go for external control, like the higher courts looking at things versus a more grassroots kind of intervention. So thinking about strategy, Eddie, I would ask you, as you've thought about this in the context of, living in the United Kingdom, but also enlightened by the experience of the United States and now by Gráinne's remark, in terms of strategy, what do you see as a way to trigger the law to make things better on the ground?
I mean, it's a huge question, and I think it's one that a lot of legal thinkers, whether they're practitioners or academics, are thinking about, because at the end of the day, like Gráinne mentioned, there's sometimes a lot of law, but then how that actually translates into effective remedies for people, or kind of a social change in thinking about what equal treatment looks like, or institutional forms or structural forms of discrimination look like. One answer is that it's about being on all of these levels at the same time, which sounds kind of like a cop-out answer, but in a different way, I guess I'm trying to say that activism and practice needs to be aware of the structural and institutional levels, even when doing cases that are individual cases. So that means understanding the importance of intersectional types of claims in getting us to rethink equality law, for example. But also, on the other hand, we need to be able to name the racism in other forms of social harm. So, for example, the Grenfell disaster in the United Kingdom affected lots of people of color, lots of people, lots of Muslim people, lots of people who were did not have settled status, immigration status. And so how does housing, the way that housing or precarious housing affects certain communities, how do we frame that as a question of institutional and structural racism? I think the legal practitioner has to know that language as well as knowing the current language of discrimination, which is really difficult, but something tells me that force is going to come from outside of the world of legal practice. So the leaders of that are activists and organizers, bereaved families, people who are doing work socially that needs to then be taken seriously in the legal setting. I think that's how we get to a place where we're not producing laws that don't have the right effect, but rather integrating all these levels of the problem.
And towards that goal, what's the strategy for enhancing social engagement? Is it making race not as a biological idea, but as a social construct, more of a central element of discourse? Is it so? What's the strategy for creating enough social engagement around this theme as to actually trigger the lots of law that we have in the books? How do we do that? You were talking about several states having different attitudes towards the use of the word race in itself for different reasons. You've seen the range. What works better? Do you feel that the engagement, so in the United States today, I mean, in law schools, there's a huge debate on whether race should be at the center of social change movements or not. Even today, it's not an acquired truth, right? Not everybody agrees by no means. Where do you see, I mean, the British approach of talking about race, of taking data, maybe not systematically, but some data, versus the French approach of not taking data at all. How do they score? I mean, if you had to rank them, what would you prefer?
Well, I certainly think that being able to articulate the problem in as much resolution as possible is much better than not being able to do that. And in that sense, I think the French system really misses the opportunity to identify racism, structural and individual types of discrimination. So if I had to rank them, I think at least, you know, the UK would be coming out on top. But I think there's another dimension to it, which is that I think there is a tendency to isolate race as kind of a particular problem and then see other problems that are of comparable importance or you know, more or less important, but different. And I think integrating a racial, the analysis of race into other social challenges is really important. So for example, you know, the violence that gender categorization does to a society, I think should be seen through a lens of race as well. So how does race and gender categorization, how do those constructs work together to produce certain outcomes in society? So that's just one example, but I think that integrating a racial analysis into other forms of oppression and subordination is really important as maybe a strategy to unify and coordinate different struggles, at least. Yeah.
I have a question from the audience, from Sultan Dugan. Thank you, Sultan. So may I read it to you guys? So I'm acting now as the moderator of the questions, right? So let me read this to you, okay? So great presentation, dear Eddie. I enjoyed the EU comparative perspective you provided. Are there comparable cases of Black people being killed by police in other EU states that have similarly remained unresolved? I am also asking because there have been similar cases within Germany that have involved Muslims. Marwa el-Sherbini, who was killed in court by an Islamophobe, and her husband being shot at by the police for trying to defend his wife. But also the ongoing NSU cases, murdered Turkish shop owners, that has been routinely concealed by police, when in fact the trace leads to the police itself. Do you know of these cases, and are they talked about racial cases within legal discourse or in prosecution? Marwa el-Sherbini is in Germany, used to talk about the most crystallized case of anti-Muslim racism.
Mm-hmm. Absolutely. I mean, that case, so there are a few horrible things about that. I mean, not only was Marwa killed by someone who was targeting her for being Muslim, but the fact that police shot her husband in the courtroom when he went to, he was trying to, I think, rescue her because she was killed. She was, I think, murdered in the courtroom, and he was trying to rescue her, and the police shot him. Then, on top of all of that, and I think this also underscores another register of the problem, a media professor wrote about how this illustrates racial thinking in policing institutions in Germany. And she was then, she was threatened with a libel suit, but it was because she had talked about the potential for this to have potentially been racist or provoked by some racial understanding of the situation. And that kind of thing, I mean, it's all of the ways in which people are prevented from having the conversation that are also really horrific. And the NSU cases, I mean, that's another, the NSU cases reminded me of the Stephen Lawrence case in the UK. So in the NSU cases, there was the NSU is National Socialist Underground, and it was a group of right-wing, fascists who were targeting and killing mainly Turkish and Turkish-German people living in Germany. Over a 10-year period, I think they killed 10 people. And the police during the whole ordeal over these years had been going after the families of the victims, insinuating that the families were involved in some sort of illegal activity. And this is kind of a pattern that we see in the other cases, not only in Germany, but in other places, the turning the victims into perpetrators through public discourse in order to justify, at least in retrospect, the activities of the police and to legitimize the investigations. But it's clear that there's that level of the problem is only developing a language. Like there's only a language developing now by people who are doing work or bereaved, or the families who are doing work around this, are getting society to kind of focus in on. So I mean, yeah, there are tons of cases, and I think part of my focus, because I've been looking mostly at people of African descent or people self-identified or racialized as Black, have experienced racism in Germany as a lens. It sometimes, I think, confuses those, particularly in the States, that I'm talking about a certain type of racism, but it certainly applies. Like this analysis certainly applies also to other people of color who are facing similar types of treatment from the police and from legal institutions. I'll also say that institutional racism as a term hadn't really been used in Germany until very recently. And that was also because of organizers and bereaved family members who were trying to find a model outside of Germany to bring in, and maybe not to replicate, but to use what was available to make the language stick and to show that there's another European country that's using this terminology. So there were meetings, I remember meetings about how to use the McPherson report in the UK that coined this term in public policy discourse, and how to apply it in Germany. And those discussions are really, really useful if they're done carefully and without trying to just cut and paste. They're useful ways of thinking about what's working or what could work from outside.
Gráinne, Professor de Búrca, I know that you have another engagement at 5:45, but I wanted to let you use the last couple of minutes to respond to what you've heard.
Yeah, I mean, I think, Eddie's comments are very, he's an expert in this area and knows all too well what's happening in various countries. I was thinking, though, from the last question that, of course, the case that's emerged again in France, the I Can't Breathe, the man, I think, of African descent who was who was trying to escape when, I think, his brother, he was trying to take shelter because his brother was arrested, and he ended up being suffocated, I think, in custody. And again, it's a year now, more than a year and a half, 2 years since then. It's interesting to me how these cases that had, where no justice was, found or forthcoming and so on, have come back and really become matters of public, wider public protest and engagement. And in some ways, this sort of spreading of, as you say, the discourse of institutional racism, because these atrocities happen in more than one country, there's something that's really, I don't know, reassuring, I guess, about the fact that actually those lessons can travel and that people can learn from and reopen cases that have been just pushed aside or kept silent and so on. I mean, it's both tragic on the one hand to say, oh my God, it's happening everywhere, the same kind of thing. But on the other hand, then once a light is shone on it in one jurisdiction, that becomes galvanizing for people trying to draw attention to the same phenomenon in another jurisdiction. So at least that is one phenomenon of transnational mobilization, I guess, that's positive. I think there's another question.
Yes, there is another question. Can I read it, Gráinne? Can you stay another minute? Yes. Sure. For context, an anonymous attendee writes, I'm a Bengali Greek who was born and raised in Norway. I experienced a fair amount of mistreatment when I was younger, and it was part of the reason why our family permanently moved to the US. I understood that racism due to my skin color. However, my father, who is Greek-Norwegian, blonde hair, blue-eyed, with all the typical Norwegian traits, was also mistreated and experienced a lot of racism too, just because he had a Greek name. Does inter-European racism still exist? And if so, do we see the same type of discrimination between the various European ethnic groups at the same scale as we do against people who are non-European?
So, I mean, I think this is one of those questions that that points to some of the differences between how we use race and how we use ethnicity, because there are certain ways in which there are stereotypes and prejudices against people from different European countries But then race brings in other forms of analysis. So for example, using whiteness as a frame of analysis and looking at whiteness as a way to understand how privilege and belonging operate in a given European society, I think is an important aspect of what race brings to the table. It's not only about whiteness, there are other inflections of it, but I think it's difficult to argue that there's an equivalence to be had. Like to compare different forms of prejudice can be really dangerous. There's also, I think, there's also critical view as to whether that the form of racism against someone because of their skin color and being non-white is equivalent or comparable to the type of discrimination you face for being from Greece as opposed to Norway. So there are ways to think about that in terms of race, but I think it would be hard to compare. And I think one view is that it's not racism per se. It might be some bias in terms of ethnicity, but race brings in a whole kind of other category of thinking about difference that is based around whiteness or can be based around a longstanding view of something that's biological in a certain way. And I'm not saying that it needs to be biological, but but yeah, there's a debate to be had as to whether or not we call it the same thing, and definitely whether we compare different forms of bias in that way.
So guys, I have a lot of questions. I would like to maybe thank the speakers and wrap up the formal session, and those of us who can stay on can continue a little bit. I'm infinitely thankful for Professor de Búrca's participation and intervention. Always a pleasure to listen to, and hope to be in touch again about the new book.
Thank you so much to both of you for inviting me, to Eddie for a really great talk, and to Daniela I was delighted to be involved. Thanks again, and I'm looking forward to joining another discussion in October that Eddie will be participating in, and that Daniela has organized.
And Sultan as well. Thank you so much, Gráinne.